The professional responsibility fact pattern from February of 1994 is a challenging and difficult PR essay question. It's difficult because we are dealing with a lawyer who is facing conflicting ethical duties. And so this question poses some complications both with regard to organization and with regard to the actual substance of the answer. The good news, if there is any, is that the examiners were really not terribly interested in the outcome. You could reach very different conclusions, in fact, opposite conclusions, about most of what the lawyer does in this problem without being worried about failing the question. But the examiners were looking for, as always, careful, detailed, logical analysis. This is a fact pattern that tests gray areas, although I personally think there are correct answers, and perhaps you will see once again my pro-defense bias coming in, if there is any. But intellectually, this is a thoughtful, well-constructed question, to the extent that any California bar exam essay question is an intellectually valid product. This one is. Take a look at the call of the question at the bottom of this fairly lengthy and complicated fact pattern. What standards of professional responsibility, if any, has Knowles violated by his conduct in representing Baker? Discuss. Well, up front, we can't do much in terms of organization based on this call of the question. And, in fact, we can only make an educated guess about what our basic format will be. We're being asked about standards of professional responsibility. That implies, I think, that it would be better to organize this answer around duties, and then, within the duties, organize the answer around the facts. Now, it's perfectly acceptable to do it the exact opposite way, organize around what happened, and then focus on the duties then. But I think that a question that involves a lawyer facing conflicts between ethical duties might be a question better answered, organized around the duties. Again, we are trying to make these decisions in order to make the answer easier for us to write than it would be otherwise, and especially because we want to make it easier for our friend, the chain-smoking solo practitioner, sitting in front of a television set after a long day of unrewarding and low-paying legal work. We want to make it easier for that person to see just how competent we are. So please turn to the top of the fact pattern with me. Let's briefly review it together. We see up front that this is a PR problem arising out of a criminal case. So we realize up front that an attorney representing a criminal defendant has a heightened duty of zealousness than perhaps a civil lawyer does. Because here, in criminal law, the attorney is the only bulwark between the defendant and the entire power of government. So we see a federal case involving bank robbery. The government charges the defendant with robbery, as it would have to, and the prosecutor's case depends on, among other things, photographic evidence from hidden cameras in the bank. One of the photographs depicts the robber, none of the photographs depicts the robber's face. In paragraph 2, we hear about the first meeting. Baker told Knowles that at the time of the robbery he was watching television at the home of his friend Peterson. So, to his lawyer, the defendant presents an affirmative defense. I am innocent of the charges. I wasn't there at the time. And Peterson is the alibi. In paragraph 3, Knowles notices that one of the bank photographs shows the robber wearing a ring on the fourth finger of his right hand. At one of the trial preparation sessions, Knowles saw that Baker had a ring on the same finger. Knowles mentioned this to Baker, and then in the following conversation, a conversation ensues. Baker says, "So what? There must be lots of rings that look like that." Knowles, the lawyer, says, "Yours has a B on it." B for Baker. Baker says, "You can't see the one in the bank photo clearly enough to see if there's a B on it." Knowles says, "You might if they blew it up." Thereafter, Baker removed the ring, and Knowles, the lawyer, never saw it again. Knowles later suggested that Baker get a new ring to cover a mark left by the old ring. So now we've got two very specific acts by the lawyer that could be interpreted in very different ways. Now, my argument, as you might predict, as you may know if you've already looked at my model answer, is that these actions by the lawyer, suggesting the client change the ring, get rid of it, and suggesting that the client cover up the mark left by the old ring, those two acts, to my way of thinking, are both entirely ethical and legitimate. And in fact, they represent the lawyer living up to his duty of zealousness as aggressively as he could, without crossing the line. I don't think that this is obstruction of justice, because the ring is not yet in dispute. The prosecution has not examined anything about rings. This is merely an effort by the lawyer to not allow for big open doors to the defendant's guilt to become evident to law enforcement. It is law enforcement's job to solve this case, and it's the defense attorney's job to make law enforcement work as hard as it has to prove every element of every charge against the defendant beyond a reasonable doubt. Next, in the following paragraph, the defendant asks the lawyer, Knowles, what might happen if the prosecutor asked him if he had a ring with a B on it. And Knowles lives up to his ethical duty of candor by counseling his client to testify truthfully. Quote, because you insist on testifying, you have to tell the truth. Here, the lawyer is living up to the highest ethical standards, the duty that he owes the tribunal and the opposition. In the following paragraph, we see evidence of the defendant's guilt, and more importantly, evidence of the lawyer's specific knowledge of the defendant's guilt. Up until these facts, the lawyer has no knowledge of the defendant's guilt. But look at what happens on the evening before the day of closing arguments. The defendant pays off the balance of his legal fee in $100 bills, and the lawyer notices that serial numbers of 14 of these bills are the same as serial numbers of stolen bills, which numbers have been revealed during the course of trial. Okay, stop right there. What is the lawyer's duty right here? The lawyer has to turn this evidence over. He doesn't have to say where he got it, but he's got to turn it in, and his failure to do so is going to subject him to discipline. So, now look at what the lawyer does next. He fails to do what he should do with these bills, and instead he returns them to Baker, and he tells Baker to bring the same sum in different denominations. The next morning, he gets paid off in 50s. The lawyer takes that money. Now look what happens in the closing argument. Here, in closing argument, the day after the lawyer became knowledgeable about the actual guilt of his client, he argues that the prosecutor was going after the wrong man, and he urges the jury to believe the alibi. And that argument is unethical, because the lawyer knows that the testimony he is arguing is perjurous. Now, he's not going to be subject to discipline for putting on that evidence, because at the time he did so, he didn't know it was perjurous, that it was false. But now he does, and so his argument is unethical, and it's going to subject him to discipline. So you can see, even though I am very much on the side of the defense, both in criminal and in civil court, here I'm not at all shy about damning this lawyer for his breaches of ethical standards, which are serious and which, as you know, I will tag him for good. Then we get the call of the question again. What standards of professional responsibility, if any, has Knowles violated by his conduct in representing Baker? Discuss. Our most important decision with regard to organization is, do we organize around the duties or do we organize around the conduct? Here, plenty of people did it either way, as is almost always the case. But take a look at the outline of issues that I present, and I think you'll see that the way I do it makes very good intuitive sense, and it sets up for an easier writing job than the other organization might do. So, have a look. In the first part of the answer, there's no internal organization, but I go through what the ethical duties of a criminal defense lawyer are. I talk about zealousness, competence, and confidentiality. Those standards don't appear to have been violated by this attorney's conduct. Yet, still, we need to consider them up front. I don't waste a great deal of time on it, but as it turns out, we'll talk about zealousness more than anything else here. This is where we are going to set up our analysis for what follows in Section 2, where we talk about the duties that the attorney owes the court and the prosecutor. Here, the lawyer has to live up to standards of candor and honesty. So, here, as is often the case, both on the bar exam and, I can tell you from personal experience, in the real-life world of criminal prosecution and defense, we've got conflicts and duties. We have to examine them carefully. So, within our analysis of Roman numeral 2, here I organize internally around the facts. And I think this is the easier way to do it, but if you did it the other way, I wouldn't be at all concerned. But notice, internally, I follow the chronology. The lawyer asks the client to remove and replace the ring. He tells him to testify truthfully. He returned tainted money, and he urged the jury to believe the alibi testimony. And you'll see I spend a fair amount of time internally on the alibi testimony. And finally, I talk about the closing argument and I reach a conclusion. So, like many PR questions, once you've got it set up, writing the answer is somewhat more like paralegal work than like legal reasoning. That's the work that we do in setting up and deciding what the actual answer is. But here, I think you will see another example of an answer that goes about the task of analysis with a great deal of care and a fair amount of precision. In fact, I think this answer is good enough that I want to offer you one of my standard caveats. You are getting a chance to review my fourth or fifth draft, and you get to write the first draft under time constraints. I have the luxury of time and preparation, and I have the benefit of many, many students reviewing, particularly an answer this old, reviewing an answer and recommending improvements. So I think this is a very nice, polished answer, even if you are able to find one or two typos, which may still exist after all these many years. But your job is to write a first draft that makes sense to a disinterested grader who is doing a reasonably professional job. So I don't think you can expect to come up with something that is as consistently polished as this. Still, I offer these consistent model answers for your perusal and hopefully for your edification. So take a look at this answer. You'll see that my response to what I headlined in Roman numeral 1 is really only a 3-sentence paragraph. But take a look, and I think you'll see that here, mostly, this paragraph is about what the rules are, although I present this legal paragraph within the factual context of the case that we're analyzing. The bulk of the analysis comes in the second section of duty of candor and honesty that a criminal defense lawyer owes the prosecution and the court. Here again, up front, I lead with the law and I explain it in the factual context. The attorney cannot deliberately hide evidence, known evidence. Plus, the lawyer cannot argue testimony he knows to be false. So now we have to carefully examine each act of this lawyer in order to determine whether or not it lives up to the proper standard. So we start off with what I think is the biggest gray area in the fact pattern, the fact that the attorney caused the client to remove the ring and then to replace the ring. And so these 3 paragraphs, the second of which is the longest and most elaborate, I think could well be worth your perusal and study. Again, I admit it took a fair amount of work to get these paragraphs into the shape that you see them, but they are, to be honest with you, reasonably close to my first draft. They're a little bit sharper and there's no grammar errors that I know of, but take a look and I think you'll see that the analysis that I present is insightful and pretty thorough. You may not agree with it. You may have reached the opposite conclusion, and to that I say this. I think my answer is the correct answer, but the committee of bar examiners didn't care about whether you think this lawyer should or should not have caused the client to remove that ring. What the committee of bar examiners cares about is that you appreciate it's an issue and that you consider it with due care and rigor before you reach a conclusion. It's perfectly okay to come up with an answer that is not correct most of the time. And here, I think that even I would admit that this is a very fine line, and very reasonable arguments can be made on either side. Still, I conclude that this lawyer Knowles did not violate any standards of professional responsibility when he advised his client Baker to remove and replace the ring. Next, we focus on the attorney's advice to the client with regard to the testimony, and here the attorney lives up to his ethical duties as well as you can expect any lawyer to. And here I lead with the facts. I've already presented a fair amount of law earlier. The second paragraph focuses on how the facts and the law relate to one another. Once again, I think this is what our primary job is on bar exam essays. We have to spot the issues, then we have to analyze the facts according to the law that we know will apply to the situation. Next, we turn to the attorney's conduct with regard to the money, and here the lawyer's conduct, as I've indicated before, clearly falls far short of what we would expect of a criminal defense lawyer. Certainly, we're not going to expect a criminal defense lawyer to turn into an arm of law enforcement. But here, he's actually in possession of physical evidence of the crime. He has ethical duties which trump the duties that he owes his client. Certainly, he's not supposed to go and narc on his client and snitch on him. But at the same time, he's got an ethical obligation to turn this cash over. So take a look at the analysis. I've got 2 paragraphs on his failure to turn in these bills and the act that he did do, which was to return them to the client. And here, I think it is absolutely black letter correct that the attorney could be subject to discipline for failing to turn this evidence over to the court. Although, clearly, his duty of confidentiality would prevent him from explaining where he got it. That's the correct answer. And I can tell you that the vast majority of bar candidates got this part right. This is an issue that we all study in a fair amount of depth. This is not a gray area, the way the earlier section was. Next, we turn to another set of conduct by the attorney that clearly falls substantially short of the attorney's duties, and that's the closing argument. So, here in section D, I lead with the facts again. The lawyer has been appraised of this alibi from the very first meeting he had with the client. And at the time that he presented the testimony of the defendant, his conduct was lawful, because at the time he presented the defendant's testimony, he did not know it to be false. So section 1, within this analysis, focuses on the direct examination of the defendant. Now, think about this. Actually, he's cross-examining the alibi witness, not the defendant. Still, at the time this witness testifies, the lawyer doesn't know that the witness is testifying falsely, but later on, he does. The direct examination of the alibi witness is one thing, but the closing argument is unethical because it violates the duty of honesty and the duty of candor that all lawyers owe to their opponents and to the judicial system as a whole. So the attorney could have presented a reasonably zealous closing argument that didn't refer to the testimony that was perjurious. So that wraps up a consideration of that analysis. And I conclude that the attorney is subject to discipline for returning the stolen money and for arguing false testimony. It's a good example of plain English for bar candidates. And that concludes an analysis of what I think most of you will agree is a complicated and difficult PR question.